Welcome to The Explainer. All right, if you are prepping for the bar exam, you're going to want to pay close attention to this one. Today, we are digging into a case that is an absolute masterclass in the laws of evidence, and really how to build, or in this case, how to completely break, a case from the very beginning. Vaughan v. Bongiorno.
Okay, let's just dive right into the problem at the heart of this thing. The facts are messy, just like in the real world. You've got a 59-year-old solicitor who gives his 33-year-old student partner a huge amount of money to buy property. Well, the relationship goes south, and now he's in a panic. Absolutely terrified she's going to sell off all the assets and just disappear with the cash before he can even get a judgment against her. So what on earth do you do?
And look, we are not talking about a small amount of money here. The plaintiff, Mr. Vaughan, he put up over $900,000 for real estate, and it was all in the defendant's name. The stakes just could not be any higher. So what does he do? He reaches for one of the most powerful tools in any litigator's playbook, the Mareva injunction. You probably know it as a freezing order. This thing is basically the legal equivalent of a nuclear weapon. It stops a defendant dead in their tracks, freezing all of their assets.
But, and this is a big but, you can't just stroll into court and ask for one of these. To use this weapon, you have to clear two very, very high hurdles. These were famously laid out in the case of Patterson v. BTR. For your exam, you absolutely have to know these two steps. So the test has two parts. First, you've got to show the court that you have what's called a prima facie case. Basically, that means if all the evidence you have right now holds up, you've got a pretty good shot at winning at trial. Then second, you have to prove there's a real, genuine danger that the defendant is about to get rid of those assets just to avoid paying you. Well, in this legal high jump competition, our plaintiff, he didn't even make it to the second hurdle. He tripped, he stumbled, and he fell, spectacularly at the very first one, just trying to establish that prima facie case. So, the really critical question here is why? Why did he fail so badly? And it all comes down to the very specific case he chose to argue in court. This, right here, is where the masterclass for every aspiring barrister really begins. Now think about this. He had a few options. He could have argued a resulting trust, maybe some kind of property relationship claim, but no. He picked one very specific argument. He said these were all just simple loans, and the single most important term was that they were all repayable the second he demanded the money back. Repayable on demand. That was his entire case.
Okay, so that's the claim he's making to the court. The deal was repayment on demand. To get over that first hurdle, he now has to back that up with actual evidence proving that exact agreement was made. So, the question is, what evidence did he bring to the table? And this, my friends, is where we get to the absolute heart of the problem. It's the evidence itself. Let's take a look at what the plaintiff claimed was actually agreed to. Right here is where the wheels just start to come off the bus for the plaintiff. For the very first property, this quote is from his own affidavit. He describes the conversation, saying it was agreed that repayment would happen upon the sale of the property. See what's missing there? There's nothing about on demand. In fact, his own evidence points to the complete opposite of the case he's trying to argue. So he tries to plug this massive hole in his case by pointing to a note he typed up for himself on his own computer. See how he added the magic words, or upon demand? Well, the judge saw right through that. That's not proof of an agreement between two people. That's just a record of the plaintiff's own internal monologue. It's completely inadmissible. And this train wreck of contradictory evidence just kept on rolling. For the other properties, it was the same story. One conversation mentioned repayment after she got a good price. Another piece of evidence just described the basis in the plaintiff's mind, not a single word of an actual conversation. Every single piece of his own evidence pointed to one thing: repayment on sale, not on demand. So, faced with this disaster, his solicitor tries a new strategy. He starts arguing very passionately that his client genuinely, truly believed that the deal was for repayment on demand.
And right here is the million-dollar question. This is the one every single one of you needs to have an answer for. Your client is sitting right there in front of you, telling you what they believe the agreement was. Is that enough? Is their personal belief the same thing as admissible evidence in a courtroom?
Well, Justice Hamilton's response was swift, it was brutal, and it left no room for doubt. This quote is the knockout punch. The evidence wasn't just weak or unconvincing, it was, in his words, utterly inadmissible to prove the case being run. So let's just boil it down. Why did he fail?
because the case he chose to plead, repayment on demand, wasn't supported by a single shred of evidence the court could actually look at. And even worse, the evidence he did submit actually argued against his own case. He literally built his entire case on foundations of sand.
So what's the big takeaway here? What is the single, most important lesson from Vaughan versus Bongiorno that you need to practically tattoo on your brain, not just for the bar exam, but for your entire career? Okay, let's break it down into 4 simple rules. 1. What your client believes happened is not evidence. 2. The evidence you present must directly and perfectly support the specific case you are pleading. You can't argue one thing and then try to prove another. 3. Inadmissible evidence is worthless. It's garbage. It doesn't matter how desperate you are. And 4. A prima facie case isn't just some vague feeling. It's built on solid, admissible evidence that clearly points to a probable win. You see, this case takes dry legal theory and turns it into a powerful, practical tool. It leaves you with the one question that you must always ask. The next time a client walks into your office and says, "It was agreed," your job has only just begun. Your very next question, the one that separates the great barristers from everyone else, has to be, what were the exact words used by each of you? Getting that answer, that is the difference between building a winning case and arguing a complete catastrophe. Remember that, and you'll be one huge step closer to success at the bar.